So, ladies and gentlemen, dear colleagues, dear students, welcome to the Sorbonne Law School. For the attendees, also for the numerous persons that are online and couldn't register for an in-person event. We are very happy to host this event here in the Sorbonne, together with Queen Mary and my dear colleagues Maxi Scherer and Maria Fanou. So the topic of today, as you know, is all you need to know about arbitration and crypto assets. And we wanted to make sure that you will not stick to the idea that crypto disputes stop at Sam Bankman-Fried and the FTX fraud. It's more than that. It's also a matter of arbitration. And that is what we wanted to address today, how arbitration is being more and more frequently used as a way of solving crypto asset dispute. So thanks again for joining us. And I will now leave the floor to Maxi.
Thank you, Matthias, and I just want to add my welcome to everyone, many colleagues, students, former students in the room and online. We actually have, believe it or not, over 500 registrations online, which is a testament to our wonderful speakers. So we're going to proceed with two roundtables. The first roundtable is looking into the definition of crypto assets, their legal status in the various jurisdictions, as well as the types of disputes that arise from crypto assets. And we have two excellent speakers who I have the pleasure to introduce, who are sitting here. Chloe Bell, who is here on my right, who is a barrister at Three Realm Building in London, and has practiced actually litigation, including litigation in crypto assets for some time. She is ranked Band 1 as a leading practitioner in digital assets and smart contracts. And her ranking has a quote, which is, I think, my ever most favorite quote of everyone I've ever heard, and that she has a supersized brain. Anne-Claire Roux, who is sitting next to her, is a professor here at the Sorbonne, Université de Paris, Panthéon-Sorbonne. She's been here for a long time, 15 years. She's the co-director of the Sorbonne Business and Financial Law Center, and is also involved with the French Financial Markets Authority, the AFM, and it looks at crypto and blockchain also from her prism, which is finance and banking. So these two will illuminate us in the first panel on crypto assets more generally, and then the second panel, whom I will introduce now, but who will be sitting in the second panel, are three specialists from the international arbitration realm. So we are focusing more on arbitration and crypto in the second panel. And here we're going to look at the various procedural and other challenges that arise from crypto arbitration, and when and if arbitration is more suitable than litigation. We're going to look at them from different perspectives. Mariel Dimsey, Dr. Mariel Dimsey, who is sitting here, is an international arbitration practitioner, has practiced for more than 20 years of experience, but brings to the panel in particular her experience, her institutional experience. She's the immediate past Secretary General of the Hong Kong International Arbitration Center, and has rejoined CMS as local managing partner in Hong Kong just 2 weeks ago. Second, Tian Bao, sitting next to her, is an independent arbitrator located in Singapore, and has, as an arbitrator, served in almost 100 cases. She also has not only the perspective as an arbitrator, but also from the institution. She is currently a vice president at the ICC and co-chair of the IBA, and is actually co-editing a book on crypto assets. And last but certainly not least, Nino Sievi, who's a partner at Natter Delafour in Zurich, and he looks at it from a practitioner's perspective, actually doing these cases as counsel quite a bit, and he has a wonderful little blog on LinkedIn on crypto and blockchain, which I recommend you read. I'm actually going to leave this panel in a second because I'll hand over to my colleague Maria Fanu. She's a lecturer assistant professor at Queen Mary, and she and Matthias are going to moderate the first panel. So I'll leave you to it. Thank you, Max.
Yep. Thank you, Maxi. So without any further ado, I will jump into the first question for our panelists. And the first question will be to Anne-Claire. It will be a very simple one, just to respect the topic for today, all you need to know about arbitration and crypto assets. So let's start with a couple of definitions. What are crypto assets? And can we possibly draw a distinction between cryptocurrencies and other crypto assets, such as, for example, NFTs?
Maxi and Matthias for inviting me to speak today. It's a nice occasion to meet some colleagues and to talk about this very interesting subject. About definition and categorization of crypto assets. They are first characterized by the technology used, distributed ledger technology, or DLT, such as the blockchain technology or a similar one. But the classification and legal regime depend foremost on the rights conferred by the crypto asset, by the token. For example, if a token gives right to a dividend or an interest and or gives voting rights, it might qualify as a financial instrument and will be subject to all applicable legislation such as MiFID, prospectus, market abuse, and so on, and this regardless of the technology used. In France, the PACT law of 2019 has provided a definition of digital assets, actifs numériques, and a framework for digital asset services and for initial coin offerings. The PACT law distinguishes between cryptocurrencies, other than those issued by central banks, and tokens, jetons. But as from 30 December 2024, the EU MiCA regulation will apply and will replace most of the provisions of the PACT law. MiCA provides a general definition of crypto assets as, I quote, a digital representation of a value or of a right that is able to be transferred and stored electronically using DLT or similar technology. MiCA distinguishes three types of crypto assets. Firstly, asset-referenced tokens, which are a type of crypto assets that are not electronic money tokens and that purport to maintain a stable value by referencing another value or right or combination of the two, including one or more official currencies, so-called stablecoins. Secondly, e-money tokens, electronic money tokens, which are a type of crypto assets that also purports to maintain a stable value, but this time by referencing only the value of one official currency. And then thirdly, there are utility tokens, which are a type of crypto assets that are only intended to provide access to a good or to a service that is supplied by their issuer. As to its scope, MiCA does not apply to crypto assets that qualify as financial instruments, and it does not apply either to NFTs, that is to say, non-fungible tokens, meaning crypto assets that are unique and not fungible with other crypto assets. They may be digital art or collectibles, or they may represent services or physical assets that are themselves unique and not fungible, such as product guarantees or real estate. The unique character is to be assessed not only at the level of the token, but also at the level of the assets or rights it represents. Otherwise, you would only have to attribute a unique identifier to a token to turn it into an NFT and to escape the application of MiCA. I should add that the fractional parts of an NFT are not themselves NFTs, and they may be subject to MiCA.
Thank you very much, Anne-Claire, for this very helpful definition and categorization. The second question that I have for you, and perhaps is one that is on the legal community's lips, is whether crypto assets are property, and thus are they subject to ownership rights?
Well, as I said earlier, in order to determine the legal status, you have to consider the rights conferred by the token. Under French law, the Pact law expressly defines tokens as intangible assets, biens incorporels, implying that they are subject to ownership rights. MiCA defines crypto assets as representation of a value or a right, which implies, on the one hand, that not all crypto assets are of the same nature. Some represent a claim against an issuer, when others represent value. On the other hand, MiCA, in particular Article 70, recognizes the existence of ownership rights over crypto assets. But then, MiCA is a regulatory text. It's not contract law and it's not property law. And as a result, there are a number of issues, especially in the event of the opening of insolvency proceedings against the custodian of crypto assets, that are not covered by MiCA and must be answered according to national law.
Regarding this specific issue related to the proprietary status, is it specific in the context of insolvency?
I think the context of insolvency definitely highlights why it matters to classify these assets as property or something else. There are lots of fraud, misappropriation cases of crypto assets, and it's a rare case where the victim of the fraud insists that they have the precise Bitcoin that was stolen from them back. Maybe less so in the context of some NFTs that aren't regarded as fungible. But where proprietary status actually matters really comes into focus in the context of insolvency. And I think it's highlighted very well by the case from the New Zealand High Court at Rusco and Cryptopia. And so it's just give you a rundown of the facts so you can see why it mattered so much in that case. So that was a cryptocurrency trading exchange that was hacked and went bust as a result. And it was placed into liquidation. And issues arose over who owned the remaining cryptocurrency that the exchange still had, and what assets were the assets in the liquidation. Ownership of the assets was important because if the investors on the platform could show that they owned the assets, then they'd be ring-fenced from the other assets in the liquidation. And the value of that's apparent in Rusco because if the account holders had a proprietary right over the assets in the liquidation would have been 5.4 million, which meant that personal creditors would receive less than 50% of their claims. If the account holders only had a personal interest in these assets, then there would be $217 million in the assets of the liquidation. So you can see why it mattered so much in that case. The court concluded that the crypto assets or the relationship between the investors and the exchange was one of trust, so that they were their property and held on trust for the account holders. So I think that's a good example of why insolvency brings these issues into focus. Other reasons why proprietary status might matter to the outcome of case are, for example, the sharp fluctuations in the value of crypto assets. For example, you might want to recover the underlying asset rather than the compensatory equivalent of it because it's gone down in value. And the taxation of crypto assets depends on their characterization by national revenues as property or not.
Thank you, Chloe. That's very interesting. I was wondering if you have any further insights with regard to the legal status of crypto assets in common law countries such as Singapore, the UK, Hong Kong. Do they all recognize crypto assets as a form of property?
I think we're getting to the stage where the answer will be yes. It's fair to say that not every common law jurisdiction has given a binding decision on that issue, including countries like Australia, which is a huge part of the common law world, hasn't really yet given a decision on that issue. But of those common law countries that have given binding decisions, they've all come down on one side, which is this is a form of property. Now, traditionally, in the common law world, we have two forms of property: things in possession, things that you can physically touch and possess, and things in action, so things that are not physical, and you have to realize your proprietary rights by taking an action in court, so like a cash balance at a bank. We don't really have any real clarity yet which category these assets, or some of these assets, and Claire mentioned that some of them have to be realized through a claim, and others might be represented through a physical asset in the real world, but we don't really have any clarity on that yet, and that's really where it will be interesting to see how that area develops, and what precisely they're categorized as, whether it's into the two existing categories or third categories. For example, in the UK, our Law Commission has just recently published a bill where it's not really expressing a view on whether it's in one of the two traditional categories, but it said, if any court wishes to find that the third category of property exists, they can do so. And they've consulted on the issue and suggested that it's probably best if they're classified as a third and separate kind of property. The Singapore Court of Appeal has also opined on the proprietary status of these assets in a case called B2C2 and Coin, and that was a court composed of senior Singaporean judges and international judges, including Robert French, who is the former Chief Justice of Australia, and Lord Mance, who's a previous Supreme Court judge. They held that Bitcoin was a form of property and could be held on trust. Subsequently, we've got the case of Bit Fintech Limited, which is a Singapore High Court case, in which they went further and said USDT, a stablecoin, was a form of a thing in action. So they've gone ahead and classified USDT as a form of shows in action. Now, query whether that's going to apply to other assets, because it's a stable coin, it's pegged one-to-one to the dollar, it's a bit like an IOU, so one can see why it's more like a shows in action than Bitcoin, for example. There are other examples. The Canadian Federal Court has made a decision that Bitcoin was property. The US is a slightly different system, but there are a number of cases that are being brought in rem, so the asset is the defendant to the litigation, by the US prosecuting authorities. The Hong Kong Court of First Instance has classified them as a form of property, or indeed Bitcoin. BVI, the same. The DIFC, so the Dubai International Financial Centre, has just passed legislation saying that crypto assets are a third kind of property. They're neither things in possession nor things in action. So I think the next wave of cases will be considering what kinds of property they are, getting into the issues that Anne Claire has raised, which is, what are these assets? What is your relationship with them? Are they fungible? Are they not fungible? And what kinds of remedies do investors look for from the courts?
Wonderful, thank you.
Thank you, Chloe. And now, and Claire, what about the civil law systems, and maybe the French law and the others?
Well, under French law, we tend to admit that intangible goods or immaterial goods, biens incorporels, might be subject to ownership rights, so that this is not really an issue in itself. But we don't have much case law on this precise subject concerning crypto assets yet. And in fact, we have more questions than answers. I'd like to mention 3 of those questions. First, what triggers the transfer of ownership of crypto assets? Can it result from a change of, only from a change of registration on-chain, in the blockchain, or can it happen off-chain, either with the delivery of the private keys, or by change of registration, in a register of positions held by a custodian. In practice, these 3 different procedures are used. The on-chain transfer might be more secure, but it takes time to validate a transaction, and it implies paying gas fees. That is why it can be more interesting in some cases to operate the transfer off-chain. So in these different scenarios, when does the transfer of ownership take place? The answer depends again on the legal status of crypto assets. If we consider that crypto assets are intangible goods subject to property law, then the civil code provides that the transfer of ownership takes place solo consensu, which means by the sole effect of the contracts. But it may be deferred due to the nature of the goods, and since crypto assets are things of a kind and fungible, the transfer of ownership should be deferred until they are individualized, which could again happen on-chain or off-chain if you put them in a different wallet. So questions at this point rather than definite answers. Second question, what rules apply in the event of the opening of insolvency proceedings against the custodian of crypto assets? On this subject, Article 70, paragraph 1 of MiCA states that crypto asset service providers, CASPs, that hold crypto assets belonging to clients or the means of access to such crypto assets shall make adequate arrangements to safeguard the ownership rights of the clients, especially in the event of the crypto asset service provider's insolvency. But MiCA does not specify how CASPs must ensure the protection of their customers' property rights, particularly in terms of segregation of accounts. We're waiting for some level 2 texts on this subject, and from ESMA too. Does the owner of the crypto assets have a claim in kind on its assets, provided that assets of the same kind are held by the custodian? That's what Chloe talked about earlier. Or because of the fungible and sometimes, not always, but sometimes consumable nature of crypto assets, does he have only, under French law, what we would call a monetary claim for the equivalent in value? On these questions, opinions differ between French academics. As regards a comparison with financial instruments might be interesting. And as regards financial instruments, there are specific provisions on this matter in the French Monetary and Financial Code. And so one might ask if we need a similar procedure for crypto assets. And third question, will a bona fide purchaser of a crypto asset be able to rely on possession to establish title against a claim by the true owner? Again, it depends. If you apply the provisions of the civil code, it states that possession is equivalent to title. But French courts do not seem to accept that these provisions are applicable to intangible things. And then we have almost the same provisions in the French Monetary and Financial Code, but they are not applicable to crypto assets, only to financial instruments. So these different issues show that in the absence of specific rules for crypto assets, it all comes back to contract law and to property law, which begs the question, do the general rules on intangible property provide satisfactory answers to these questions, or do we need ad hoc provisions inspired maybe by the rules applicable to financial instruments? It's a question that's being asked these days, considering the need to adapt French law with the provisions of MiCA before the end of the year. And all this raises a question more fundamentally of legal policy. Should investors in crypto assets benefit from the same degree of protection as investors in financial instruments?
That is an open question. Thank you both for giving us a general and comparative overview of the legal status of crypto assets according to the common law and to the civil law, and more precisely French law. So let's now move to another general topic, which would be what are the typical disputes you can face in the crypto assets world. And we're not talking about arbitration right now, we're talking about the litigation, generally speaking. And I would like to ask you, Chloe, the following question. So what are the typical disputes that can arise out of crypto assets? Maybe the first one we have in mind is fraud, especially with the current case in the US, the FTX scandal. And according to regarding this specific topic of fraud, which kind of remedies do we have? And I see several issues here. The issue of anonymity, of course, and maybe the potential liability of crypto exchange platforms as well. What are your views on this, Chloe?
Yes, so litigation in this area has broken open quite a lot of traditional legal concepts and forced us all to look at them again through a more modern lens. So there's quite a lot of scope for the common law, more generally the law of property and contract, to move with the times and develop as it's designed to do through case law. So fraud, there's a huge amount of fraud litigation involving crypto assets. And when I first started practicing this area, the vast majority, if not all of my cases were fraud cases. And the classic fraud case is a victim has had their wallet hacked or their Bitcoin stolen from their wallet through one method or another, and they come seeking some form of remedy from the court. The first thing that you normally do is go and obtain an injunction over, normally in England it's against persons unknown, so they're identified by reference to the wallet address, the transaction ID. That's just the first step, and in many ways it's quite theoretical as to whether or not that gives you a real remedy, because the assets have likely been dissipated further than that by the time you come to have the case heard. And the anonymity obviously is an issue there, but the good thing about blockchain, unlike general banking fraud, for example, is that you can trace them. You can trace assets and identify the specific token at various points. Where you run into difficulty is when the asset enters a crypto exchange, because then the kind of shutters come down and you have to obtain a disclosure order from the exchange to see where your asset went thereafter. That takes time. Sometimes the exchanges tend to push back or don't want to give you that information because they have duties to their investors. And that's an area that's still quite challenging. And once you've obtained that disclosure, you're then faced with a multitude of further transactions, and then you start having to engage with bona fide purchaser for value issues, because in English courts, they will recognize that if someone's inherited your Bitcoin, you know, doing a genuine transaction 10 jumps down the line. And then you basically have to resort to old-fashioned personal investigation and tracing the underlying wrongdoer to get any form of remedy at that point, which is not great legal advice to be giving to a client if that's what you have to do. That then means that lots of litigants have turned to the exchanges to see whether there's some way of holding them accountable for the losses, in the sense that they provided the framework for the fraud to be perpetuated, or they've turned a blind eye to bad behavior on their platforms. Inevitably, they've pushed back very strongly against the suggestion that they owe fiduciary duties or anything beyond contractual duties to investors, and that they can't know at all times what's going on in their exchanges. I think the issue in England is a lot of these claims have been brought without thinking those things through to the final answer that the investors need. So there's one case that's listed for trial in June called Deloya, which is against Binance, and they're claiming that Binance, purely by virtue of having had control of the assets after the fraud, is liable as a constructive trustee to the defrauded victim. I think that they're going to lose that case, but it's the way the case has been pleaded, and the facts of that case just don't lend themselves to finding in favour of the investors. But I do think there will be a case that comes along, particularly looking at turning a blind eye to bad behaviour that you know is going on in your exchange, and you just don't care. Our laws haven't developed that far yet, but I think this kind of litigation will bring into focus those kinds of issues.
What about the creator of the blockchain? I'm not talking about Bitcoin, because we still do not know who is the creator of Bitcoin, but other blockchains. What about the creator? Does he or she have a kind of duty of care or something like that?
Yeah, well, interestingly, the English High Court a number of days ago did give clarity that the creator of Bitcoin was not Craig Wright. So we know who it isn't. But yes, so there is litigation on foot, unsurprisingly, perhaps, by a corporate entity associated with Craig Wright, and it's called Tulip Trading, and it's being brought against the developers of the Bitcoin network. And the facts of the case are Tulip Trading is the company name, is incorporated in the Seychelles, but it's brought litigation in England saying that they are the owner of 2 wallets that hold about $4 billion of Bitcoin. But unfortunately, the private key, the thing that allows the owner to actually transfer and realize the asset, has been lost, apparently through a hack. So the case is that the developers actually owe a duty to investors where they've been defrauded to effectively rewrite the network, recognizing the rightful owner as the owner of the Bitcoin where they can't access their wallets. And the claims being put, one, that they have a fiduciary duty to users of the Bitcoin network, but also tortious duties to those users. That case is listed for trial. It hasn't yet taken place. There's been a bit of a controversial start to the litigation because the first instance judge kicked it out for being unarguable on grounds of jurisdiction, and the Court of Appeal then let it back in. So it's just really getting started as regards the substance.
When I hear you, we all have this idea that the blockchain was immune from hacking, but in fact, I can hear the word several times in your mouth, meaning that there are some hacking process in the surroundings of the blockchain. And
I've actually done cases where a white hat hacker has seen a flaw in the code, and they've used that flaw to grab assets that have been obtained through fraud, and then they patch up the...
Yeah, that was the case with the DAO, I guess.
Yes, yeah, exactly.
But as I've been raised as a private international lawyer, I was wondering if we now move to, let's say, private international issues, like what could be the jurisdiction, which domestic jurisdiction can you go to, what is the applicable law? Do you have any ideas on that?
I think the law is currently quite underdeveloped in this area. We've got a handful of injunction cases in England that have talked about the asset being located where the owner of the private key has their domicile or habitual residence. And the Singapore High Court has come to that conclusion as well. The English Law Commission has just commenced a consultation on this particular issue as regards applicable law, and I think they probably will come down on the side of it being where the private key holder is physically situated, which feels a little bit unsatisfactory because you're basically ascribing the crypto asset a proxy through a person, but equally proprietary remedies are about a relationship between a person and a thing. So I think that's where the law will end up. Jurisdiction, I think the EU has very powerful mechanisms for jurisdiction for individual investors where they're classified as consumers. And they are being deployed effectively in cases where an individual investor needs to go to the local court to obtain a remedy.
Yeah, when the claimant is a consumer, but for example, if you have an IP dispute, would that work?
In terms of where the...
Yeah,
no, I think... Yeah, it would be looked at differently because it would be where the defendant is located, or you would have to look at a whole host of different factors. But the IP dispute that I referred to earlier involving Craig Wright, none of the developers were located in England. But I think they were all relatively happy to have it heard in England because they knew that the trial would go, it would be a fairly run trial and so on. So, yes, but I think there's definitely more in this area to come, and certainly more precise and reasoned judgments to come.
It's still a work in progress.
Yes, very much.
Thank you, Chloe. And Claire, maybe if we continue a bit our comparative exercise, how does the landscape in civil law jurisdictions, France, by way of an example, look?
One of the earliest cases, maybe the very first one, before the adoption of any specific legal provisions applying to crypto assets, concerns the Mt. Gox platform, the Tokyo-based Bitcoin exchange that's very suddenly disappeared in 2014. The case took place before that, and it concerned a company which was the European partner of the Japanese company managing the platform. It would collect the funds paid by buyers for the purchase of Bitcoins in a deposit account opened with a bank, and pay them to the sellers after payment of a commission. And in 2013, the Paris Court of Appeal ruled that this activity constituted a payment service under the Payment Services Directive, and thus required authorization as a payment services provider. More recently, there have been cases of fraud where intermediaries have been prosecuted. But to my knowledge, there has been no bankruptcy of a French crypto asset platform whose operator was registered with the AMF. There have been criminal proceedings for fraud or for misleading commercial practices, and of course there have been liability claims. In a few cases, liability claims have been brought against the company managing the platform, which raised the question of jurisdiction again. For instance, in one case, a customer opened an account and created a crypto assets portfolio on a platform which was managed by a company based in Lithuania. His account was hacked, and he lost about 300,000 euros. So he filed a complaint for fraud, and he sued the company for damages. The contract provided for the jurisdiction of the courts of Lithuania. So this raised the question of whether the customer could be considered a consumer within the meaning of the Brussels 1 bis regulation. This question arose because in this case, the customer had participated in the creation and in the development of a new cryptocurrency, and he received a cryptocurrency donation in return. And he then made a profit by converting this cryptocurrency, and the funds that disappeared proceeded from this profit. In 2021, the Court of Appeal of Montpellier ruled that these elements were insufficient to exclude his status as a consumer. As a result, the Montpellier Judicial Court had jurisdiction and not the Lithuanian courts. This ruling is in line with the jurisprudence of the European Court of Justice as set out in the Petrushova and in the Reliant co-investment judgments, which concern not cryptos but CFDs, but the legal issue remains the same. That being said, in most cases, unhappy investors are unable to recover their funds from intermediaries and platforms which are usually based abroad. So in France, they will turn to the only solvent party available to them, the bank that holds their account and that executed the transfer orders when they subscribed to the investment. Of course, this issue is not specific to crypto assets. It concerns more broadly customers who have carried out speculative transactions, for example, on the Forex, or who have made unfortunate investments in so-called atypical products, whether wine, solar panels, diamonds, or, of course, cryptos. In this scenario, the bank did not act as an advisor during the investment, but only executed the transfer orders. And the payment transaction was indeed authorized by the client, so the bank is not liable in its capacity as a payment services provider. But in its capacity of account holder, the bank has a duty of due diligence, devoir de vigilance, and is required to detect anomalies. But under French law, this duty of due diligence must be balanced with the duty not to interfere in its client's affairs, which is why the bank is required only to detect apparent anomalies, which has raised some questions. For instance, what if the beneficiary of the transfer is on a blacklist published by the AMF? Does this constitute an apparent anomaly? And there have been a number of rulings on this issue over, in the last few years, in particular by the Paris Court of Appeal. If I have 1 minute left, I would like to say a very quick word about another case which addressed an issue that is really specific to cryptos. What is the nature of a loan of crypto assets? And what happens in the case of a fork during the term of the loan of crypto assets, such as the fork that led to the creation of the Bitcoin Cash in 2017? Should the Bitcoin Cash revert to the lender or to the borrower of the Bitcoins that have been loaned? These issues arose in a case between the UK company Bitspread and the French company PAW. In a judgment from 2020, the Commercial Court of Nanterre reasoned by analogy with the lending of financial securities. It held that Bitcoins being fungible and consumable goods, the loan of Bitcoins is a so-called consumer loan within the meaning of the civil code. And therefore, the borrower became the owner of the loaned Bitcoins. He was entitled to keep the Bitcoin cash, and he did not have to return the Bitcoin cash resulting from the fork to the lender, so to the French company.
Thank you so much, Saint-Clair, for this wonderful overview of the French jurisprudence here. Being mindful of the time, and unless Matthias has any other questions, okay, I think we will thank you both for this wonderful setting the scene for the next roundtable, and we're very ready to see what happens when crypto assets meet arbitration.